Yes, Mr. Kufani.
May it please the court. I appear for the appellants, Mr. and Mrs. Tirumalesh, who are the parents of the late Sudiksha Tirumalesh. My learned friends, Miss Gollop, King's Counsel, and Miss Kirkbride, appear for the official solicitor, who was Sudiksha's litigation friend in the proceedings below. Mr. Sakdeva, King's Counsel, Miss Dobson, and Miss Bueno appear for the respondent trust, and Mr. Ruck, Keane, Honorary King's Counsel, and Mr. Allen appear for Mind, who is intervening in this matter.
Yes. Thank you. Now, Mr. Gundvali, I'm sure you've got some housekeeping matters, but we've got some housekeeping matters. So
the few, if I could assist on a few perhaps of the housekeeping matters. The first is to say that, perhaps unusually, but there are no reporting restrictions extant in this case at the moment. So we're not we don't have to be careful not to mention
the case was supposed to being live streamed. Ah, right. It is, right. So just so that everyone understands that the case is being live streamed.
The second matter.
I'm sorry to interrupt. I had an email from Professor Kitzinger who says it's not worthy.
Right. Thank you.
The second matter that I hope I can assist in part is that, as regards my learned friend Mr. Sakdeva's application to adduce further evidence, from our side we have no.
Well, I'm going to deal with that, the bundles and evidence in a moment.
The other matter relates to the objection my learned friends made to the supplementary skeleton argument, which was filed essentially at his suggestion, but it was meant to be of assistance in focusing the issues which remained under dispute. And I just wanted to reassure my learned friend there was absolutely no intention and to raise any matter relating to declarations of incompatibility. Quite the opposite. It was just saying that very broad interpretation was available to the court when dealing with these matters. But I don't propose to say anything more about that, except I was concerned that we didn't spend too much time perhaps on that issue, since it wasn't a major part of my argument, and the submissions that were to be made were very brief, and perhaps it would be better if I were able to make them and the court can decide whether they stray outside the confines of my original skeleton argument, which I don't believe they do. Those were the issues I hope to assist the court with.
I'll deal with mine then, shall I?
Yes.
Can we just see how we're doing? Could you just check for me?
It's working.
Working?
I'm viewing it myself, and Professor has confirmed.
Good, excellent. Good. So first of all, the unagreed bundles, the objections to chronologies, the filing of numerous supplementary skeleton arguments without permission, without any applications. We're going to look at everything de bene esse, but can I just remind everyone that really in litigation as important as this, it's extremely unattractive if the parties can't agree, and the poor masters have to deal with school playground disputes between the parties about what is or is not going to go into the bundles. It's not helpful. It also makes it very difficult to prepare because nothing is in the right place. We haven't got a clear picture of what's going on, and it's very unhelpful. But we will be reading everything. In fact, I think I can assure you that we already have. Also, the bundle of authorities is quite extraordinary, Mr. Quintavali. It's neither alphabetical nor chronological, and I have no idea on what basis the authorities bundle was put together. But
it might be reverse.
It's in reverse chronological.
Reverse chronological.
First for me.
But so it's extremely difficult to find your way around, and there also still seems to me to be some omissions, but we will all get through it because the issues are so important. So, which brings me on to the next point. One of the reasons the official solicitor's skeleton argument is miles over the practice direction length is because of the litigation capacity argument, which seeks to be argued. I, for my part, and we have an opportunity of discussing this, litigation capacity is not part of this appeal, and we will not be hearing any submissions about it, please. We've got enough to deal with within your grounds of appeal, Mr. Quintavalle, and the issues dealt with by the judge. The same goes for inherent jurisdiction and the vulnerable adult issue as a potential alternative to capacity. That undoubtedly is a very important issue, but it's for another day. So if I can just be absolutely clear for all those involved in the case and involved in a wider aspect of the case and who may be on live stream, we are not for 1 minute saying that the issues of litigation capacity and vulnerable adult and leading to the use of inherent jurisdiction are not extremely important matters, which eventually will have to be considered, but it would be wholly inappropriate to squeeze them in to this appeal when they would require very detailed consideration and detailed skeleton arguments. And at the moment, we've only got that from the official solicitor. Which then leaves us finally, I think, subject to my lords having anything else that I've missed out, we think that the additional issues that you've raised in your supplementary skeleton argument, Mr. Quintavalle, don't take matters any further. And we want to stick to the issues that are raised within the skeleton argument. So we are not giving you permission to amend your grounds of appeal or to deal with those matters, additional matters in that skeleton argument. You don't need them. We're very clear that we've got everything that we need within your argument.
So just to be clear, there'll be no submissions on by analogy to the Article 5 jurisprudence. I'm grateful.
Yeah. Now, is there anything else? Before we start on the substance of the matter, anything else that we can usefully do to clear the decks so that we can all concentrate on the very difficult issues the appeal raises? No? Have you agreed between you time estimates for submissions?
Yes, my lady. I was anticipating to take about probably 3¼ hours, but I hope to have half an hour, 3/4 of an hour left in reply at the end. Mine's submissions will be half an hour, and those of the official solicitor were between 1½ and 1¾ I think Mr. Sackbeaver was planning to have about 3½ hours.
Whatever's left. No, I'll see.
3½ hours?
Yeah.
Goodness.
Otherwise, I'll just tell you to read it.
Well, I should say that we have read very substantially. We've all spent at least a day reading into this matter. So I hope that will be of assistance for us to focus on the really difficult issue. And I think that we all are agreed that one of the most difficult issues in this, thrown up by this appeal, is the issue of belief. That's of any assistance to anyone when you're concentrating on your submissions. Over to you, Mr. Quintavalle.
Grateful, lady.
Oh, I'm sorry, one last thing. Are the parents either in live stream or present in court?
The parents are present.
May I offer you these sincere condolences on behalf of all three of us. We're very grateful that you've come today, and we realise that this must be yet another extremely difficult day for both of you.
Thank you very much. Thank you.
My lady, my lords, this is an appeal against the order of Mrs. Justice Roberts of the 7th of August 2023, in which a finding was made that Sedictia lacked capacity both to conduct proceedings and to give withhold their agreement to medical treatment. The case does cover a lot of legal ground, and I'm grateful that the court has narrowed it down so that we can exclude the important issues of litigation capacity and vulnerability under the inherent jurisdiction. I propose to start my submissions just by looking, hopefully quite briefly, at how these proceedings came to be before Mrs. Justice Roberts, because it will be important for the court to understand how we arrived where we were, and it does go to the issues of fairness, which are part of several of the grounds that of appeal that I'll later be dealing with. The background to this appeal essentially starts in November 2022, when Sadiksha, who was in a very fragile state after an emergency laparotomy had been performed due to the misplacement of a catheter which had perforated her stomach and had left her at risk of death. She made a lasting power of attorney in which she appointed her parents as the donees. And this was registered with the Office of the Public Guardian on the 18th of January 2023. The Trust was concerned about this, and they didn't accept the validity, or they had doubts about the validity of this lasting power of attorney. So on the 22nd of February, they issued proceedings to challenge its validity. And those can be found at Core Bundle, tab 7, page...
Well, Mr. Quintvine, what is that issue going to, given that the lasting power of attorney didn't form part of the proceedings with which we're concerned? I mean, I can quite see from the parents' point of view that the fact that it was challenged was distressing, and I completely sympathise with that, but I'm not sure what its relevance is to what we're dealing with.
One of the issues that's arisen in this case, and it is one which centres on, essentially on the procedural fairness of the proceedings. And a lot of evidence was put in as a result of the various proceedings which and the applications which were made. But what I wanted to show is that the way the whole procedure developed, there wasn't an effective chance for Sadiksha to, or indeed for her parents to challenge a lot of the evidence, which then went up, which eventually was evidence which Mrs. Justice Roberts relied upon in her judgment. And it's understandable why she did. It's understandable how that evidence came to be before her. But it's a rather strange and convoluted history to how we got before Mrs. Justice Roberts. And just taking the court through a few of those steps might help illustrate the problems that were faced. One of the issues that's been raised by my learned friend, Miss Gollop, relates to the fact that it's a suggestion that it was inappropriate that Sadiksha essentially had two sets of representatives before the hearing before Mr. Justice Peel, and also...
That's not part of this appeal either. You're here and we're extremely glad that you are. And we're also very glad that the official solicitor is here, because we get two different approaches. And Mrs. Justice Roberts, for my part, quite rightly agreed to you coming in, albeit in rather unusual circumstances. But she too was grateful that you were there on behalf of Sadiksha. So I don't think that it's going to be an issue we have to decide in this appeal. What one does or what the proper procedure is and whether it was right or whether it was wrong. What's important in this case is that the family, if I can use the broadest sense, was represented in the way it was and remains.
Another issue, and I just mention it and then we'll move on, but it is important, we say, is that these proceedings advanced on the basis of an interim declaration, which was made by Mrs. Justice Roberts at a previous hearing that held that it appeared that Sediction didn't have capacity. And this was an issue that had been raised at some of the hearings before, also by my learned friend, Miss Scholar. There was a concern about whether the court did have jurisdiction or not to entertain the matter, or whether it was appropriate to proceed just to have a best interest hearing. And that
jurisdiction to hear what?
To determine a best interest application when the issue of capacity hadn't been resolved, hadn't been established. And it's just, that's the only real issue I wanted to highlight. That we arrived, it was essential to have a capacity hearing.
Absolutely.
Mr. Justice Peel made the right decision. But there was a very real risk that if it hadn't been for a last-minute intervention on behalf of Sediction, that the hearing may have proceeded to a best interest hearing without the capacity issue having been resolved.
No, I'm sorry. You're going to have to take me through the. That's not my understanding at all.
Well, if we have a look at the skeleton argument.
Well, I'm sorry to interrupt.
Yes.
But the position was that Mrs. Justice Roberts made an interim declaration. That's only that there are reasonable grounds.
Yes.
To believe. There is reason to believe. Page 62 of the supplement. That doesn't resolve the issue of capacity, does it? You have to go on. There had to be a decision on capacity before any best interest.
Yes.
You could have done more of the same hearing, I suppose. I don't know whether that was ever suggested, but at any rate, the question of capacity had to be determined before best interest was looked at.
Yes. And that was a decision which Mr. Justice Peel, we say, rightly made, that it had to be determined beforehand. But the hearing before Mr. Justice Peel was originally a directions hearing to determine a best interest hearing, which the trust had made an application to hold. And so this was at a point in time when there hadn't been any establishment of Sedictia's lack of capacity, except for this interim declaration.
But the parents have, on the 12th of April, the trust made an application to the court to perform a capacity assessment, which was opposed by the parents. Then on the 13th of April, as you rightly take us to, Mr. Justice Roberts made the interim declaration and appointed the official solicitor as a litigation friend and gave permission to the trust to instruct an expert to conduct a capacity assessment. And thereafter, there's various other orders, extra experts and so on, second opinions and so on. So capacity was front and centre. I'm not sure how you say that there was ever a risk that capacity wasn't going to be decided.
Well,
it was absolutely the issue.
The skeleton argument of the trust, the one that's part of the addendum bundle, the additional evidence which the courts accepted, shows that at that point, when that skeleton was prepared, the trust position was that the court needed to proceed to a best interest hearing. And the position of the official solicitor at that hearing, and unfortunately his skeleton argument isn't before the court, but her position at that hearing was that it was essential not to delay the hearing to decide these jurisdictional issues, as it was put, but there was a need to proceed to a best interest hearing. Now, my lady, my lords, I don't want to belabor this point, but it's only to say that the fact that there was a capacity hearing was not a given. In fact, it was quite possible, if there hadn't been an intervention at the last moment on behalf of Sedicia, that the court would have proceeded to a best interest hearing without having resolved.
I'm really sorry. As I've made very clear, we are extremely glad to have your role confirmed in this hearing today. But on the 26th of July, there was a directions hearing before PLJ, and he listed a hearing specifically to determine capacity. So it just isn't right to say that if you hadn't come into the case at the last minute, capacity would never have been decided and it would have gone straight to a best interest decision.
Well, maybe I'm not making that submission. Mr. Justice Beale may have made the decision to that capacity needed to be resolved quite independently of any decision of any intervention that we made. But originally, as listed, the hearing was to determine direction for a best interest hearing. It wasn't to determine a capacity hearing, and that hearing was all about what should happen, and the decision which was made. We say the right decision was made by Mr. Justice Beale that we needed to have a capacity hearing before the best interest hearing. But say we can. I don't think it's necessarily particularly useful because the fact is we did have a capacity hearing, and this is what the challenge is about. But if one looks at the trust's skeleton argument, it's clear that they were, and the application that they've made, which led to the hearing before Mr. Justice, it was that there was a best interest hearing.
Are you taking us through this aspect of chronology to demonstrate that in some way these matters infected the judge's ultimate decision on capacity? If not, what is the relevance to this appeal?
The relevance is only... The relevance relates to the evidence that was before the judge, or the lack of evidence from Sedicia and from her parents.
So this links into your fourth ground of appeal.
Yes, it links. It's a fairness ground because there was a whole load of evidence which had been put in anticipation of the best interest hearing, and that information, and no doubt my learned friend will take the court to it. There was a lot of medical information, and the bundles before the court have been greatly culled. But there was a great deal of information. This was before Mrs. Justice Roberts. It was medical information, which was relevant to best interest determination. It's information we say wasn't directly relevant to the capacity determination. But in any case, it's evidence that we didn't have the chance properly to oppose or to rebut. And that was simply the point. And I can leave that there and pass straight on to the grounds of appeal. But it was in my submission just important for the court to be aware of this issue, which had been of concern to various of the parties in the proceedings before, as to whether capacity needed to be determined before the best interest hearing could be held.
So just so forgive me if I'm slow, what you're going to submit further on in the morning is that there was some evidence before the judge which she took into account, that played a part in her decision on capacity, which wasn't agreed and you hadn't had a chance to challenge.
In short, yes. And it related. There were a lot of issues which if there had been a best interest hearing, there were a lot of issues under dispute in this case, underlying medical issues. There was an issue of whether Sudiksha's condition was due to progressive organ failure as a result of the mitochondrial disease, or whether it was due to long COVID and the problems she had had in the hospital, and whether she was recovering from that. There was an issue as to whether there was treatment available in North America, whether this was a realistic and viable option. And these were important issues, quite apart from quite independent of the capacity issue, but they were ones which then did form part of Mrs. Justice Roberts's reason.
Well, you'll show us exactly where
Yes.
they did and why you say it was unfair when
Yes.
we get to your ground 4.
But I'm mindful not only of my lady's concerns, but also of the fact that the court has read the documents. It won't have seen, because they're not before the court, the skeleton arguments that the various parties have submitted to the prior hearings, but they do demonstrate, and if the court, they are documents that my learned friend, Mr. Sacklever, did want to put before the court, but we were mindful of the restrictions on the size of the bundles. So I'm sure that if they were necessary for the court to look at them, they could be, if they were necessary, they could be made available. But I do stand by the submission that I make. Mr. Justice Peel may well have decided quite independently that it was essential to determine the capacity issue, but there was opposition to that on the part of both the official solicitor and...
There was opposition to that.
There was opposition.
It was an opposed application for there to be a capacity hearing.
Well, it was a directions hearing for best interests.
I know, but a best interests determination can't take place unless the capacity issue has been resolved.
Yes, and that's...
And well, anyway, just let's...
And that's why Sudiksha's application was about that, saying, I want to have my voice heard. I don't believe that my capacity that I'm incapacitous. We need to resolve this before we have the best interest.
And everyone agreed, and the judge agreed, and it happened.
Well, they did eventually agree, but it was a battle, my lady. That was the only point I wanted to make. It wasn't it wasn't something that was immediately it wasn't something that was immediately obvious to everyone. Anyway, if I could proceed to our grounds of appeal, which I would like to...
You had a water disaster.
Yes.
Do mop up, because it's very distracting for yourself if you're trying to stem a flood at the same time as make submissions.
I propose to address the grounds of appeal slightly out of order, if I may. I want to start with grounds 1 and 2 considered together.
Yes.
Since they deal with the same factual underpinnings, and they both engage principles of procedural fairness. Then after that, I'm going to turn to grounds 3 and 5, insofar as they relate to the so-called diagnostic test, and then 4 and 6 after that.
All right. Thank you.
We say, and this is submission which underlies our grounds, that there were 3 relevant factual questions which the court needed to determine and upon which it needed evidence. The first question was whether there was an impairment of or a disturbance in the functioning of the mind or brain, and that's the statutory language. And if the court will permit me, for simplicity, for the remainder of these submissions, if I could refer to that as mental impairment rather than ungrateful. So that's the first question. The second question is whether there was an inability to make a decision. And the third question is whether the mental impairment was responsible for the inability to make a decision. The causal question. And the first 2 grounds...
Tell me again how you've put that. Was the mental...
So the first question is...
Question 3.
Question 3, the causal question, whether the mental impairment was responsible for the inability to make a relevant decision. There are 3 quite separate questions, and when we get to the Supreme Court in JB, we see that they were only dealing with the second and third questions, and I'll make some
why they were wrong.
My submissions are that they were entirely right, but why their approach was entirely compatible with what
Well, I'm
we
glad about that because I may be brave, but I'm not that brave.
So evidence from three witnesses. There was evidence also heard from a fourth witness, but it didn't relate to capacity. But there were three witnesses who gave evidence to the court on the capacity issue. And they were the consultant psychiatrists, Dr. Bagshi and Dr. Miners-Wallace. And their instruction came from various orders that had been made by the court. As we saw, my lady took us to Mrs. Justice Roberts' original order at the time she made the interim declaration. And that's when Dr. Bagshi first got involved. And then Dr. Miners-Wallace got involved afterwards when the trust who had instructed Dr. Bagshi wasn't, for whatever reason, very happy with with Dr. Bagshi's conclusions. And so they asked for another expert to step in. And the third clinician, the third doctor who gave evidence was Dr. Tunnicliffe, who was a consultant intensivist. And we say he was properly a witness of fact in this matter. He wasn't an expert witness on capacity, but obviously he'd been treating Sudiksha, and it was important that his voice was heard. Dr. Miners-Wallace, in his first report, which can be found at tab 6 of the core bundle, and I'll be taking the court, if I may, to a few of the passages there, very helpfully provides a detailed chronology which deals with Sudiksha's medical background, but also to the various statements and interventions on the issue of capacity. And if I could take the court to page 117 of the core bundle, tab 6. So we see there at the bottom of the page, this is when Sudiksha first was admitted to the hospital, but we see recorded the views of 5 people who were involved in her care, who recorded it in various ways that she had capacity. But if I could go forward to page 119, at 6.7, we see that for the 27th of October, and this happened to be just a few days before the medical emergency that, for which Sudiksha needed the emergency laparotomy. But we see Dr. Hill noting that a concern that a do not attempt CPR had been put in place, but this had not been discussed with Sudiksha, and there was no indication that she did not have capacity to discuss this. So this was the trust had alerted to this problem. And at 6.9, a month later, on the 22nd of November, we see again the same concern repeated. And then on the page, go back to page 108, at entry 4.111, we see a record from the vulnerabilities team, again noting that that no formal MCA assessment had been documented. What then happened on the 19th of December, we see this on the same page, is that an MDT meeting was held. And we see at the very bottom of the page, at 4.117, that attempts to establish capacity unsuccessful so far. Just the note by way of parentheses, but this, of course, not an accurate way of putting matters, because, of course, capacity is presumed under the Mental Capacity Act. So it's not that one has to establish capacity. One has to establish that there isn't. But nonetheless, they were unsuccessful on the 19th of December to resolve this issue. And on the 20th of December is when Dr. Bagshi was first involved. And we can see this at page 58. I'm sorry. We can see this on page 122 of the core bundle, tab 6, which again is from Dr. Miners-Wallace's first report. But he records Dr. Bagshi's visit. So his first one was on the 20th of December, paragraph 6.14. And Dr. Bagshi says, so far I've not seen anything to say her capacity is compromised except when her ability to engage was compromised by her discomfort and pain. And then at 6.15, Dr. Bagshi visited Sudiksha again the next day. And the last line of the notes records that it's clear that she has capacity to engage in her care, though she wishes her parents to be part of that. There's another visit, but it's not clear who Dr. Bagshi visited. But at page 109 at 4.124, we see for the 29th of December 2022, a visit from Dr. Bagshi explained meeting with ST and that ST has capacity. As we saw on the 22nd of February, the capacity was challenged, and that led to Dr. Bagshi again being called to assess Sudiksha, but this time as a result of the order of the court. And that resulted in Dr. Bagshi's first report, which can be found at tab 6.1 of the core bundle at page 79. And I'm mindful that the court has read these documents, but if we could just look at the bottom of page 81, where we can see Dr. Bagshi's conclusions. And 2 lines from the bottom, he says, I did not find her to have any difficulty in understanding given information about her illness. She also recollected events and conversations with other doctors. And then over the page, she explained to me her wishes to be treated as far as possible, and as it's going, I did not find any evidence of any impairment of or disturbance in mind or brain at this time.
Well, you missed out the last line, no doubt, inadvertently. I've not been able to explain to her end-of-life care. She simply will not step.
Yes, and that was an important important concern that motivated the trust to want to explore this issue further. There was this concern. In fact, Dr. Tunnicliffe, in his evidence and cross-examination, says that he believes Sudiksha had capacity for all decisions, just not those relating to end-of-life care. So that was an issue. But
is it also important to note that Dr. Bagshi said that he did not think that her views were out of any delusional nature? Line 6, page 182.
It is important, and I'm grateful to my Lord for highlighting that. And that's been a recurrent issue, the delusion issue. And both Dr. Miners-Wallace and Dr. Bagshi were clear throughout, and in their cross-examination as well, as we shall see that there wasn't a delusion. The notion of a delusion was raised by Dr. Tunnicliffe, but in fact it isn't one, again, as we'll see, that Mrs. Justice Roberts accepted in her judgment. So,
can I just be, so just for clarity while we're on Dr. Bagshi's quite extensive and supportive involvement with the family, was one of the issues in front of the judge the fact that Dr. Bagshi actually didn't at any stage, as far as I am aware, go through the mental capacity test?
That may well have been the concern of the trust
But that would be a concern for everyone, wouldn't it? And a legitimate concern on
Yes.
the part of the judge, because if at the end of the day he says in very bald terms you've taken to them, and that's the way he expresses himself, she's fine, she's got capacity, but without any reference to mental capacity at all, that's inevitably going to, from the judge's point of view, determining capacity, significantly undermine the value of that evidence, isn't it?
My lady, I accept that. As far as the judge's function is concerned, and certainly no criticism at all is made of the trust for seeking another report.
I thought it was.
Well, an alternative might have been to ask Dr. Bagchi to make a new assessment with the Mental Capacity Act very much in mind, but I'm not privy to those discussions, and there may be reasons why that he wasn't prepared to do that, or why he wasn't asked. But even absent the express reference to the Mental Capacity Act, nonetheless, his evidence does have weight, we say, and it was, in fact, Mr. Justice Peel invited a further report from Dr. Bagchi at the directions hearing. But Dr. Bagchi then, he prepared a second report on the 11th of May, which can be found at page 83 of the core bundle, tab 6. And we look at the middle of the page. She was quite forceful of her views of being mentally well. She was coherent and logical. And then his conclusion, in conclusion, I found her today to be less tired, more communicative, engaging well, discussed her illness and current condition as she saw it. She wanted to have further consultation from different doctors if possible, as she said she did not trust these doctors and what they're doing. I found her open to discussion and reflective and capable of listening, absorbing information given, and form her opinion. His third report was prepared further to the order of Mr. Justice Peel, and that can be found at page 86, tab 6. And Dr. Bagchi met with Sudiksha, it appears, on 4 separate occasions, and examined her on 3 of those occasions. And my lady, my lords, I again mindful that the court's looked at these documents, but in my submission, the report shows a young woman very well aware of what she's facing, very well aware of what her medical treatments entail, and very clear that she rejects the palliative care pathway, which the hospital wanted her to accept.
And you relied on what he concluded at the bottom of page 88. I found her to be able to understand information given to her, retain them for a period, to consider them, debate them if needed, counter her conclusion, communicate clearly when able to do so.
Yes, and he also says, in summary, over these 3 shortened interactions over 3 days, I found her to be fully alert and cooperative. She did not show any sign of compromise of her cognitive function. She had good memory of our conversation a few months back, as well as from day to day. She was in good spirit, and I did not find any sign of any mental disorder at this point in time. And then his conclusion on page 89, I do not find any reason to believe that her capacity to engage in the discussion about treatment decisions to be compromised, hence believed to have capacity to give valid consent about her treatment. And his evidence, the transcripts of his cross-examination, which I won't take the court to, but they're at tab 18 of the supplemental bundle, pages 134 to 163.
So 134.
To 163.
Thank you.
And he was subject to robust questioning, but remained firm in his opinion. His expertise as a psychiatrist was not questioned, nor was his integrity and impartiality challenged in cross-examination.
Were or weren't?
Well, not, he wasn't. The Dr. Miners Wallace produced 2 reports, and the first report, in which he concluded that on the balance of probabilities, Sadiksha didn't have capacity, was produced in circumstances where Sadiksha she refused to collaborate with him, so he wasn't able to engage with her and question her.
She wouldn't have anything to do with him, would she?
She had been examined by Dr. Bagshi, and she believed that I don't want to be giving evidence.
It was done. I don't want to do it. I don't want to talk to him. I told him.
So Dr. Minus Wallace had to do the best he could, and he produced a very comprehensive report in which he looked at all the medical background and came to his conclusions. I just want to record his instructions at paragraph 13.1, which is on page 145.
Yep.
At 13.1, he says, I've been asked to consider the 4 functional tests of capacity before I consider the diagnostic test of capacity. And I just mentioned that because...
You would say that's wrong.
In this case...
Notwithstanding JB, you say that's wrong.
We'll get to that shortly. It's not that it's wrong, but it explains why he approached the matter in that order, because he'd been expressly asked to do that.
Right.
But the important report is his second report, which can be found tab 6.5 starting at page 151. And by this time, Sadiksha had agreed to speak to Dr. Minus Wallace. And as a result of speaking to Sadiksha, his expert opinion changed completely. You see this at 177, paragraph 14.1. So he now says that it is my opinion on the balance of probabilities that ST has capacity to make decisions about her care and treatment. And pages 179 and 180
So he again goes through functional first.
Yes.
He finds 14.7 she doesn't understand.
Yes.
She can retain, she can't weigh up. But then that's not as a result of mental impairment. Because of, does that summarise his position?
Yes, it
And
is.
therefore it's because
And
there's no cause to link to mental impairment that he concludes that she has
Yes.
capacity.
and at 15.3 on page 180,
Yeah.
he's explaining why his opinion changed.
Yeah.
I've now had the opportunity to interview ST and found her at interview that she was an animated individual, able to engage and participate in the discussion. She was looking forward to the future, in particular expectation and hope that she would get better with nucleotide therapy. She was planning further education. She reported being very supported by her family. Then at 15.4, he'd underestimated her resilience. 15.5, clinicians are clear there's no evidence of any underlying structural brain damage as a result of her disorder. And
what was the date of this interview? I'm sorry.
it was sometime between the 27th of July and the 5th of August, so I'll have a look.
Okay, that's right. So never mind. So it's end of July, beginning of August.
Yes,
Thank you.
It's the 4th of August.
Thank you.
Page 153, paragraph 1.3.
And then if we look at 15.8 on page 180, it's not my opinion that ST is a mental illness to be diagnosed using one of the standard classification procedures. Then at 15.10, he's considering the delusion issue, and he dismisses the idea that her views were delusional as to the belief in the nucleotide therapy. All three of ST's family believe that there is a possibility that nucleotide therapy will be of benefit. And this was also one of the points which Mrs. Justice Roberts picked up on for rejecting the delusion view as well. We'll see later. Then at 15.14 on page 181, in summary, it is my opinion that ST's failure to understand the nature of her illness and hence her to be able to weigh up the facts in a decision-making process is not because of an impairment of mind, but rather a result of the shared beliefs that she holds with her family. And then he considers the litigation capacity issue, which we don't need to consider. Again, I don't propose to take the court through the transcripts of the cross-examination, but they can be found at tab 18, pages 163 to 184.
Thank you.
And again, my submission, it shows that under robust challenge from the trust, Dr. Miners-Wallace stood firm in his professional opinion that Sadiksha had no mental impairment and suffered from no delusion. And his report clearly did comply with the instructions that he received and also very clearly considered the Mental Capacity Act at every step. There's no complaint can be levelled against him on that front. But in my submission, what makes Dr. Miners-Wallace evidence particularly compelling is the fact that he changed his mind. Undoubtedly, seeing and interviewing a patient was crucial in this situation for being able to conduct a proper mental capacity assessment. When Dr. Miners-Wallace hadn't had that benefit of interviewing, speaking with Sadiksha, he formed his own opinions quite understandably. But after he spoke with her, his reasoning, his previous reasoning had to be abandoned. And he was honest and admitted it. And that, in my submission, makes his report, particularly his second report, and his evidence that he gave particularly compelling. But it also shows the necessity of speaking with Sadiksha in this case, given the condition.
Just for my note, Mr. Kutabari, could you just highlight don't develop at this point, you'll come back to it, the paragraph numbers where the judge dealt with this part of his evidence?
Well,
I know you're going to come to it, but just for my note, I know it's an indulgence, forgive me. When we come on to it, where will we be looking? Just give me the paragraph.
pages 46 onwards, so it's for bundle tab 5.
Yes.
From pages 46 onwards, I'll have a look at the paragraph numbers, and I will make.
We'll come back to that.
Some
Like
reference.
a flag. Because
Yes.
obviously,
No, I wanted to
the
look.
Chinese treatment of
Yes.
evidence is central to your case.
It is,
Right, well,
and I'll be getting to it very, very shortly.
So, Dr. Myers-Wallace is Dr. C, and the analysis of Dr. C's evidence starts at paragraph 44, I think.
Great.
yes, that's right. In addition, you'll tell us where in her discussion section, from page 68, paragraph 72 onwards,
Yes,
she deals with that part of the evidence to which you just referred.
yes.
I'm flagging that up for you to do pretty in your time. But that's
I'm grateful, but I can respond. I can respond immediately, but I'll take the court to the precise paragraph. But she doesn't deal with. Well, I'll take the court to.
It's your case that she doesn't deal with it sufficiently.
Well,
In a sentence, so that I've got.
she doesn't deal with this. What precipitated the change of mind? And
You'll develop it in your own time. But that's. I'm just flagging that up as being something, for my part, I would be interested to hear what you
Yes.
say.
Then, just look very briefly at the evidence of Dr. Tunnicliffe, because two witnesses were called to give evidence by the trust. They were Dr. Tunnicliffe and Dr. Patel, and they were both. Dr. Patel was a consultant anaesthetist and intensive care specialist, and Dr. Tunnicliffe was a consultant respiratory doctor and intensivist. And they both gave in cross-exam. Well, Dr. Patel gave evidence relating to a totally unrelated matter, which doesn't have anything to do with.
What was that?
It was to do with the size of
Whether it was a 5 or a 6.
Yes.
Yeah.
It was a concern the family had, and it was felt appropriate to address it at the
Sorry,
hearing.
that's shorthand, but obviously
Yes.
that's, we all know from
It had nothing to do with capacity, but it was felt important to deal with the issue then.
Yes, well, I hope
so
that would have been helpful for the family, very sensible,
Yes.
given that they'd been understandably very preoccupied by it.
But Dr. Tunnicliffe instead did venture into opinion evidence regarding capacity. And his examination in chief starts at supplemental bundle tab 18, page 93.
Do you want us to turn that up?
I was going to take the court to a few passages.
Certainly.
But perhaps if I just refer to the passages.
Well, we're very happy to go. If you want us to look at them, we're more than happy to look at them, Mr. Quintali. So you want us to go to the supplementary bundle?
Pages 96 to 97.
Thank you.
This is during Mr. Sachdeva's
Yes.
question.
So this was the point my lady had picked up on. So this is line 1 and 2 on page 97 about, I think, SD's capacity for almost all decisions around her medical care, with the one exception of the concerns of her dying and her ultimate death. Then if we look at page 99, where he's asked by Mr. Sachdeva, what is your view as to whether ST has an impairment of or a disturbance in the functioning of the mind or brain? And his answer is, in my experience, I can find no evidence of psychiatric disturbance. However, I do not find that she has the ability to weigh up the pros and cons of accepting treatment that would allow her a comfortable and dignified death, because she fundamentally does not believe or accept that she is dying. I think that, in my own words, that becomes a delusion. And then at line 18, he repeats that. I believe that she does have a delusion around the likelihood of her survival. So just very.
And then Mr. Sachdila asks a question, or makes an assertion, followed by a question. Delusion in law is a fixed false belief that is not explained by a social or cultural background. Do you think she has the delusion?
Yes.
And he replies, as we see.
Now, of course, that's the reason I'm focusing on this. Of course, Mr. Justice Roberts rejected delusion.
Yeah.
But the reason I'm focusing on this is because ultimately, this was the only basis in any of the evidence that had been presented to the court on the capacity issue, whether it was from the experts or from Dr. Tunnicliffe, which provided the material for a finding of an impairment, of a mental impairment. But that was rejected by Mr. Justice Roberts. So I just wanted to look very briefly at cross-examination by Mr. Garrido, page 105, where Mr. Garrido asks at line 1, Doctor, what psychiatric expertise do you have to be able to give opinion evidence about whether or not your patient is delusional? And the answer, I'm a trained physician, so I would have undergone training in psychiatry as an undergraduate. I have no postgraduate qualifications in psychiatry. Then the only...
Well, I think we need to read on, Mr. Quinfarley, because it does go to one of your grounds of appeal, because it's then put by Mr. Garrido, who was leading you on that occasion, I think. So in that respect, when determining whether your patient suffers from an impairment of mind or brain, you would defer to the appropriately qualified expert instructed by your trust, would you not? And he replied, no, not necessarily no. So at times, as doctors, we're expected to assess the capacity of our patients, and that is a requirement of any doctor, not a psychiatrist.
Yes.
So that's important evidence, which goes to your ground of appeal that says it's got to be
It is important.
a psychiatrist or a...
It is important. And in most contexts where people are having to make decisions about capacity, that's entirely appropriate and proper that a decision is made by someone even who isn't a psychiatrist and would be looking at that. But what we will be saying is that when the court is called upon to make a decision, and when capacity itself is under dispute, then a higher standard, evidential standard is called for. But I'll get on to that,
Certainly.
to that ground in due course.
Do you want to look at, do we need to look at the long answer he gave to Mr. Garrido in the second half of page 105?
I was going to take the court to that. I'm mindful it's long. It is.
We just read that through to ourselves.
Yes.
Would that be helpful?
Yes.
Because this goes to what Mrs. Justice Roberts ultimately concluded in relation to mental impairment, doesn't it? That's what he's saying here. We'll read it to ourselves. Yes, thank you.
So, Dr. Tunnicliffe there, and it is an important passage, it explains essentially his own ethical dilemma as a treating intensivist. He wants to do what he's sure is best for the patient, but the patient's simply not accepting what he's saying. What can he do in those circumstances? She won't accept that she's dying, and she wants the opposite of what he advises. He can't. Frustration in my submission comes through there, and that's really at the root of, really goes to the heart of this dispute.
Where do we say, just take me to the line where you say his frustration's coming through?
So, where he's saying in line 29, saying, I would not find it unusual for patients under those circumstances to not wish to listen to my opinion. But the rejection that she is dying means that capacity around decisions about her dying are impossible for me. And then he stops. I cannot get to the point of accepting capacity there because she cannot and will not weigh up the pros and cons of an approach. But I hope I'm not putting a gloss on that. But that's how I interpreted this evidence. She's not accepting that she's dying. What can I do? And this is the problem I've got. I want to offer treatment, but if the patient doesn't accept that she's dying, I'm in difficulty.
Again, just to flag it up, for my part, I will be looking to see how the judge factored that answer into her reasoning, paragraph 72 onwards in the judgment. Don't go to it now, but that's obviously would seem to be an element of the evidence which one would expect to feature somewhere in the analysis.
And then the final part of his evidence, which may be helpful for the court to look at, is starting at page 106.
Mm-hmm.
Mr. Garrido's asking about unrealistic beliefs. And then Dr. Tunnicliffe on line 3 of the page says, I would rather not use those words. I do not agree with what you've just said. I think that it is not a legitimate position to disregard all the facts that have been given concerning the precarious nature for respiratory failure, the requirement for organ support, the likelihood of any benefit accruing from an experimental treatment that has no experience in adult patients with this condition. There is no evidence of benefit when someone has such severe organ dysfunction as a consequence of this disorder. So dismissing all those facts is not legitimate for me. It suggests that someone does not accept or believe them to be true. Now, I believe them to be true facts, and so either I am delusional or the patient is delusional. I say with respect that this doesn't follow. And if one substituted the word wrong for delusional, then it would make sense of that evidence. And that would be true. Either I'm wrong or the patient's wrong. It doesn't mean that one's delusional, we say, just because one disagrees with the doctor. So looking now, turning to Mrs. Justice Roberts' reasoning, and before we get to it, just to summarize where we were once all the evidence had been given. We had two psychiatric experts who both agreed that Sadiqa had capacity and did not have a mental impairment. That there was a disagreement as to whether she was able to satisfy the functional test, but there wasn't any disagreement on capacity or mental impairment. We say that the evidence, given the dramatic reversal by Dr. Wallace, is significant. There's also, and this is something that the judge didn't consider because the report hadn't been submitted to the reasoning hadn't been submitted to the court in time. But it's nonetheless not a matter of no significance, and that's that the Court of Protection visitor who visited Sadiksha to assess her capacity had also found Sadiksha to have capacity. This is after the LPA had been challenged. Dr. Wallace and Dr. Bagchi were both originally instructed by the Trust. And they both expressly held that Sadiksha was not delusional. And another important point, which will ultimately go to fairness, is the fact that Mrs. Justice Roberts turned down, refused an application made on behalf of Sadiksha through Moore Barlow's to instruct an expert, because Mr. Justice Peel had provided for an application to be made by Moore Barlow if they wished, and they duly made the application within the time provided. But Mrs. Justice Roberts said it was unnecessary. Supplemental bundle, tab 17, page 88. Records the reason. So she's concerned about it being an imposition on Sadiksha, but she also says it isn't necessary. Essentially, the expert evidence that's been commissioned is sufficient.
So what's your complaint about that, given that both the experts were...
There's absolutely no complaint. In fact, there was no need to challenge that decision, because in the end the experts agreed with Sadiksha. But the point is, in Mrs. Justice Roberts' reasoning in her judgment, she held that it wasn't necessary to have any other expert evidence because we have the experts. And the experts then gave their evidence, but then that was rejected by the judge. So
the judge is entitled to do that. I mean,
yes.
You can challenge why she did it.
Yes.
I'm not sure how this ties in with with the application you'd made for... Because
we say she is entitled to, and this is one of the later grounds that I'll be dealing with. She is entitled, but then she has to give reasons, and she has to have material upon which to base a disagreement.
So this application was made by... You didn't interrupt you. Sorry. That was discourteous, I apologise. But have I got it right? This application was made by your side?
Yes. I wasn't representing the parents at this.
After the reports were available from Dr. Wallace and Dr. I'm sorry.
It was before they had been prepared.
Thank you.
There's a short window of time between the 27th and the 4th, and
yep.
An application was made within the time, but Mr. Justice Roberts said, no, the experts we have is sufficient to determine this question. But the submission is this, and as my lady rightly says, it's open to the judge to reject the experts. But then, if she rejects all the experts that are before the court, the question is, well, perhaps that evidence wasn't sufficient then. So if we turn to page 46, tab 5 of the core bundle, we have the judgment of Mr. Justice Wallace. And if I could start by just looking at page 55, which is where the expert evidence starts. And what we see there is that the heading, the expert evidence, applies to all the evidence. That was provided by experts, and also Dr. Tunnicliffe's evidence, which we say wasn't expert evidence. And it is important because it does go to it's obviously within the judge's discretion what evidence is admitted and what weight is given to that evidence. But we say it's wrong that the experts are treated essentially same plane as the non-experts with regards to this evidence on the psychiatric evidence on capacity.
In her judgment, the judge acknowledged the different specialisms of the prospective witnesses, did she? She deals with Dr. Trying to work out where she introduced them.
I think my old paragraph 20 onwards, general comments.
You should describe what Dr. A is. What his
Paragraph
specialism.
3, I think.
Certainly not in the section dealing with Dr. Tunnicliffe's evidence. Yes, in paragraph 3, as my learned friend points out.
She doesn't say what his specialism is, or doesn't allude to his specialism here, does she?
No, he's
Well, I think it says leading his care on the ITU.
Yes, so one could infer from that he was the intensivist consultant, or that she must have realised. She knew that, obviously.
yes. But within the section, starting at paragraph 27, it isn't explained. He's put in there along with the real respect experts. That is the ones that the court had asked for evidence from on the psychiatric issues.
Was it part of your case before her that Dr. A's evidence was not expert evidence on this issue?
I believe it certainly was. I can look at our closing submissions, or perhaps
I assume you invited her to confer the evidence of Dr. B, Dr. D and C over Dr. A.
and we'll have a look at our closing submissions, which I think will.
Are they in the supplemental bundle, or are they?
They're in supplemental bundle 43,
Page 40.
tab 8. Yes.
Thank
Might
you.
I just offer a note because obviously we're very glad to have Mr. Quintale here today acting for parents, but then he was acting for Diksha with the Greedo. So I think there is a point to take some care about his submissions below. They're on
so.
No. But, I will go through the procedural ins and outs of this case. It's extremely complicated, and there were various representatives for parents. I think at least 3 different barristers acted for parents during the case itself, but their services were dispensed with shortly before the final hearing. And so these are the submissions of the alternative representatives for Diksha.
Thank you.
So if I could take...
It's paragraph 9 on page
It is.
45.
Great.
Mr. Sachdino's intervention is giving me that. Paragraph 9, page 45.
So this very point was
So you
made.
did take the point.
Yes.
Not an expert.
So these were
No
submissions.
expertise in cigar.
Yes. There wasn't time during the hearing to make closing submissions, so the judge invited written submissions, and these were those made by Moore Barlow.
Thank you. Now, we were in the judgment, I think.
Yes. So, page 61, paragraph 44. So this is Dr. Miners-Wallace's report, in paragraph 44. The judge is dealing with his first report, and she says, 3 lines down, his first report in April 2023 reached no specific conclusions because Esty was unwilling to engage with him at the time. And then that's it. There's no further exploration of anything related to the first report. And it's understandable because it wasn't then relevant. We had the second report. But what we do say is relevant is the fact that he changed his opinion. And one of the reasons he changed his opinion because he'd been able to meet with Sadiq. And what we do say is that the reasoning ultimately that Mrs. Justice Roberts adopted for holding that Sadiq did have an impairment was in fact the reasoning that Dr. Miners-Wallace had adopted in his first report before he had met Sadiq. So, page 73, paragraph 92. Here the judge gives reasons why she prefers Dr. Miners-Wallace's conclusions to those of Dr. Bagchi with regards to the functional test. And when we look at the JB argument in due course and the order at which the question should be approached, we say that one shouldn't have in fact got to the functional test if there wasn't a disorder to begin with, but that nonetheless we accept for the purposes, the judge was entitled to come to this conclusion. It was, and reasons are given as to why she prefers Dr. Miners-Wallace's approach to that of Dr. Bagchi.
At 92.
Yes. It's not. More reasons may have been helpful, but in any case, that was a decision which was made as to which of the 2 experts' approach was preferred. We'll say later that it was wrong in functional test before in circumstances where the question of whether there was a disorder was in question. But if that's wrong, then certainly the judge was entitled to come to the conclusion she did. At paragraph 95, page 74,
Justice Baker.
I don't want to. I know I'm speaking a lot. I apologise for interrupting. Are you going to come back to paragraph 93, or are you not going to make any submissions on it?
I don't have any written submissions on it, my lord. I'm happy to answer. I mean, we will get to when we the final line of paragraph 93 about information being shown to be both reliable and true. I will have something to say under another ground, because there is a problem about. There are two problems. One relates to the information upon which we say the parties, Rejection, her family didn't have an opportunity to challenge. This was the evidence about whether she was in fact dying of multi-organ failure, or whether it was the effects of long COVID, whether or not there was treatment available. So there's a fairness issue there, because evidence is assumed to be true, a lot of it on the basis of the short email, the letter from Professor McFarland, that this wasn't evidence which was able to be challenged, or which the family had been able to produce any evidence to rebut. So there's a question mark over whether the court was entitled to establish that certain evidence was true. And then we get other evidence or other propositions, are those relating to the future. Prognosis. Sadiksha is going to die in a few days, in a few weeks. And in short, our submission on that is that sort of evidence is not one which can be shown to be reliable or true, because it's uncertain. It concerns a future event, and predictions had already been made by the treating team that Sadiksha was at the end of her life many months before. In fact, that was put to Dr. Tunnicliffe during cross-examination. So, as far as reliable and true is concerned, we'll have submissions to make on law, because when we look at some of the cases, the Pre-Mental Capacity Act cases, which are dealing with, on the belief ground, whether people need to believe information is true, we have to see whether this belief that they're required to accept relates to a future prognosis, or whether it's belief about something that's happened. So in the MM case, we have a lady who's being physically abused by her boyfriend and is in denial about this. And in that context, we say that perhaps Mr. Justice Mumby's what Mr. Justice Mumby had to say about belief can be understood. There's an objective fact. You've been stabbed by your boyfriend. You're not accepting this. Your inability to believe that means that you can't make decisions. But it's very different when one's talking about disputed facts and facts which relate to the future, to prognosis. And that may be one way to distinguish those. But I don't want to jump ahead of myself. But on paragraph 93, that's how I would deal with the point that's made there. Paragraph 95, Mr. Justice Roberts rejects the fixed belief theory urged on her by the trust and by Dr. Tunnicliffe. And then in 98 to 99, we have the rejection of the delusion.
I was going to ask you about that, Mr. Quintavalle. Can you show us if there is any passage in the judge's judgment where on your submission she accepts anything that Dr. Tunnicliffe was saying? Because at this passage she appears to be rejecting his suggestion that there was a delusional.
Yes, and that's one of the problems. What she does agree with Dr. Tunnicliffe is that there's an impairment.
On what basis does she accept that?
Well, and that's the problem, because the only basis that was proffered essentially was this delusion or fixed belief.
Well, that's what I'm getting at. I'm not sure, and it may be my fault. I'm not sure that she refers to Dr. Tunnicliffe's evidence to support her conclusion on it. But do you say that she is referring to Dr. Tunnicliffe's evidence?
When she speaks about delusion?
No, about impairment.
Well, the submission that I'll be making is that she essentially went off piste.
Right, that's fine. I understand that. But if that's right, then I'm not sure that it's going to matter very much. Your earlier submission about she treated Dr. Tunnicliffe in the same way that she treated the two genuine expert witnesses. You may be right about that. You may be wrong. I'm not sure it's going to matter if she didn't actually base any of her reasoning on the evidence of Dr. Tunnicliffe.
My lord, I accept that point. What she did accept was that there was an impairment, and that's what Dr. Tunnicliffe.
Yeah, I understand that point.
And so, perhaps at this point, if we have her opinions on paragraphs 101 to 103. But we don't have any explanation for disagreeing with the experts. That is our concern. And if I could conclude this ground by looking now at the case of Re G and B, which is at tab 35 of the authorities bundle. Paragraph 17, which is on page 619. And here the Court of Appeal says it is, of course, axiomatic that judges are entitled to disagree with an expert witness, but this proposition also has an equally obvious corollary. There must be material upon which the judge in question can safely found his or her disagreement, and he or she must fully explain the reasons for rejecting the expert's evidence.
Sorry,
and
which paragraph are we on?
17 on page
Got it, thank you.
619. So what my submission here is that the Court of Appeal has identified a twofold requirement before a judge may depart from expert evidence. First, there must be material, and second, full reasons need to be given. But in the present case, we have neither. Having rejected essentially all the material which was put forward by the expert witnesses or the other witnesses as to how one could found finding of mental impairment, there simply wasn't any material left before the court, except for the judge's own reasoning. And secondly, no reasons were given in any case from departing from the expert evidence, from the expert opinion. And that's grounds 1 and 2, essentially.
The reasons are really in paragraph 103. You said 101, I think it's 103. She expresses her conclusion in the first sentence and then identifies makes a number of points. Adversely impacted by the trauma of her initial admission to hospital, exacerbated by the length of her stay in the ITU, surrounded by patients dying, endured almost a year of intensive medical and surgical intervention, frightened by the prospect of dying. And then the sentence that begins with the words, the cumulative effect of her circumstances.
Yes, and what I say there is that these are essentially the reasons that Dr. Miners-Wallace gave, finding that Sir Dixit didn't have capacity on the balance of probabilities in his first report, but which he then rejected. So he's essentially adopted the same reasoning and hasn't explained why Dr. Miners-Wallace was wrong in his first report, if that's the reasoning that is adopted. Dr. Miners-Wallace does explain why he rejected that reasoning. So it was incumbent upon the judge, if she was going to adopt that reasoning, to explain why Dr. Miners-Wallace was wrong in his rejected.
So that's grounds 1 and 2.
That's grounds 1 and 2.
Thank you. So then you're going to deal with 3 and 5 together, are you?
Yes.
That's very helpful, thank you.
So this ground relies on judgment of this court in the case of Reedy,
It was a permission to appeal.
in which permission was given by the court.
But permission to appeal judgments aren't relied on in these courts unless under the rules specific permission is given for them to be relied on.
My understanding of the practice direction on the citation of authorities is that precludes the use of judgments, permission to appeal decisions where permission's refused. But in this case, permission was granted by the court to appeal.
I'd have to look at that.
And
I'm sure you're right, but
it's
that
paragraph
wasn't my
21 where permission is given for the appeal. I mean, there sounds, apart from the practical reasons which were identified by the practice direction, that otherwise there'd be a huge mass of authorities that people would have to sift through. But there's also a constitutional reason why a permission to appeal decision where permission's been refused can't be cited, because of course one doesn't know whether that reasoning is correct or not. There's an opportunity to appeal it.
No one's objected to you referring to it extensively.
The objection is
Justice
that
Baker does, but he's keeping quiet.
The test on permission to appeal is different from the test on appeal. It's a different issue being argued. But I don't want to make up more time. You want to rely on it. Let's
You want to rely on what I said at paragraph 30.
I do, my lady. That's it. Page 412, I believe. Authority bundle, tab 23.
Evidence from a suitably qualified person will be necessary as to the diagnosis, usually a person with medical qualifications. Why does that mean it has to be a psychiatrist or a psychologist and no one else?
So, the point I want to clarify at the outset of this ground is that the ground as drafted picks up on the wording used by my lady in the judgment, which is the professional diagnosis. There's a difference between a professional diagnosis and a formal diagnosis. And a lot of the objection has focused on, and the authorities which have been cited looked at cases where there was certainly a professional diagnosis of impairment, but there may not have been a formal diagnosis in as much as the professional was able to identify precisely what the impairment consisted of. But what we say is that when the court is called upon to determine a question, and I'll be looking at, apart from RED, I'll be looking at what the Mental Capacity Act Code also has to say about this, that there is a need for a more formal approach to the issue of evidence.
Well, I mean, this is very, very far-reaching. So this submission, isn't it, Mr. Quintavalle? Because, for example, we all know in the deprivation of liberty cases, it's very often social workers who make the assessments of capacity. You're saying that shouldn't be allowed?
The issue is...
Well, you're saying they're allowed to do it, but then they're not allowed to... But then if capacity is challenged, their evidence isn't satisfactory? Because they're not
the question
a psychiatrist? Or, I mean, I really do need to understand this, because your fundamental submission really upturns the approach that we have to assessment of capacity across a wide range of areas, not just end-of-life cases. So I need to be really clear where you're going with this.
So a professional is a broad term. It's not a term that, even in cases where there's a suspicion of whether it's end-of-life cases or cases similar to this one, it may be that the psychiatric evidence is totally inappropriate, or there may be better experts who can give that evidence. For example, if the problem is purely neurological, if someone's in a coma, then a psychiatrist is not the correct person to give the evidence, and a neurologist would be able to diagnose that someone's in a coma. In other cases, cases, for example, of maybe intoxication by alcohol, then one doesn't need a specialist or an expert in that respect. And the person can make a diagnosis even if they're not, maybe even if they're not a GP. But the point is, there has to be an appropriate person making the diagnosis in a situation where capacity is where it's under dispute. And in most of the authorities that are before the court, the very few authorities where capacity, that will be taken to perhaps by my learned friends, but the very few authorities where capacity was in dispute, or rather where the existence of an impairment was in dispute. And even on the cases which my learned friends refer to, the North Bristol's NHS trust case or the Pennine case, the fact that there was an impairment wasn't the issue under dispute. The difference in this case is that the dispute is precisely over the issue of whether there's an impairment or not. And furthermore, it's a situation where not only is there a dispute, but there's no prima facie reason for believing, submit, that there could be an impairment, because there's no history of mental illness. It's not a case where someone had previously been sectioned under the Mental Health Act, as happened in the Bristol case, where there's an established history of suspected psychiatric impairment. this is a case where there's no history whatsoever. There's no suggestion that the mitochondrial depletion leads to mental impairment. It leads to all sorts of other very serious problems, but there's no suggestion that it's correlated with mental impairment. So what we have is a situation where the court is being called upon to determine the question of whether there is a mental impairment. And in those circumstances, it is necessary to have a professional diagnosis. It isn't enough for we say, and with respect to Mrs. Justice Roberts, for a judge to base a finding of presence of an impairment in the absence of effectively any.
So your submission is that if the issue is impairment for a court, in those unique circumstances, the judge cannot go behind the expert evidence. Because there was expert evidence here, which you say is what there should have been, and there was expert evidence which said there was no impairment, and she disagreed with that. Now, we've already discussed the fact that if there's material and reasons, a judge can disagree with an expert. But this current submission, I'm worried, might be seen to be undermining that submission, because what you seem to be saying is when it's impairment, the court has to expect the expert testimony.
Yes, and
so you'll say if it's impairment, that's an exception to the general rule that a judge can disagree with an expert.
Situation of disagreement could arise because two experts give different opinions, as Dr. Minus-Wallace and Dr. Bagshi did on the question of the functional test, and then the judge can choose one opinion over the other. But if there's one approach which may have been open to the judge, if she had felt that neither expert evidence was appropriate, was to commission a further report. And of course, that's how disputes, and this is one of the issues which was very much at the forefront on my reading of Re D, which was at the forefront of the court's mind there, was that all the procedural safeguards which existed in a case where one of the parties disagrees with the expert opinion, and that the procedural safeguards to be able to put questions to that expert or to commission another expert to rebut that expert.
But that was a case of, I think I described it as procedural anarchy.
Yes.
When there hadn't been any, there simply hadn't been any assessment.
There hadn't been?
An adequate assessment at all.
Yes.
This poor woman, she turned up on her own, having had a litigation friend first time, and turned up on her own.
But
so I'm just not seeing how that ties in with Re D. But what I really want to be clear is are you saying that where there's impairment as the key issue, that the judge has only got two options, either to accept the expert evidence for or against impairment, or if he or she isn't satisfied by that evidence, to commission a third sort of decider report, but he or she is not entitled otherwise to disagree with the expert evidence on impairment.
it's important, I submit, to recall that the presumption under the Act is that someone does have capacity.
Of course.
So it's not
Always.
that one has to search around until one finds someone who says differently. If the evidence isn't there to suggest that there is a mental impairment, then it would take, or at least very weighty reasons to not to follow the expert opinion. And this goes back, I appreciate, the submissions made under grounds 1 and 2, but perhaps if I could look at what the code has to say about situations of what the code calls formal assessments. the authorities bundle paragraph tab 63, page 1196. The two paragraphs I'd like to take the court to. The first is 4.42. So this is under the heading, who should assess capacity? And it says, more complex decisions are likely to need more formal assessment. See paragraph 4.54 below. I'd like to take the court to that paragraph after this one. A professional opinion on the person's capacity might be necessary. This could be, for example, from a psychiatrist, psychologist, speech and language therapist. So the professional, it includes, and then it says social worker as well. It's a broad term. The professional is there to advise. Then if we look at 4.54.
Well, hold on. But the
Sorry.
final decision
Yes.
about capacity must be made by the person intended to make the decision,
Yes.
not the professional who is there to advise.
Yes. A professional doesn't determine the issue whether there's an impairment or not. That decision is for the court to make in this circumstance. But the code is looking at all sorts of situations. A lot of them are not involving courts making decisions.
Yes.
But if we look at 4.54 on page 1202, there we say in some cases it may be a legal requirement or good professional practice to undertake a formal assessment of capacity. And then over the page, one of these situations is whenever the Court of Protection has to decide if the person lacks capacity in a certain matter. Now, this is relating to the broader question of capacity, not impairment, which is part of the capacity question. The reason why I submit that there does need to be, and in this case, medical evidence, this is not a social worker who's going to provide evidence of capacity in a disputed impairment case, is because of the serious consequences of the decision that's going to be made. And one of the consequences that the court was very much alive to in Re D was the fact that the decision as to whether someone wasn't going to have a litigation friend or was, when they needed one, would affect their Article 6 rights. And here in this situation, where this finding of capacity or of the existence of an impairment and therefore, and then subsequent finding of a lack of capacity, was one which led directly into best interest hearing. The order of Mrs. Justice Roberts provided for the two-day best interest hearing, which was then going to take place, which was going to determine whether life-sustaining treatment needed to be removed. And my submission is that where a matter as serious as that is before the court, it wasn't, and this is the point made in the appellant's original skeleton argument about the principle of legality, that it's true that Parliament, when it enacted the Mental Capacity Act, didn't expressly provide that medical doctors had to provide an opinion on issues of impairment. It's not there. But what Parliament didn't confront, in my submission, and why the principle of legality is relevant to this question, didn't confront a situation where, having specified that there had to be an establishment of a mental impairment, that this was going to be left potentially to a decision of a judge in the absence of effectively any medical evidence whatsoever. And because the issue is so serious, the consequences of finding of lack of capacity, they should be imported into the sort of decision that Mrs. Justice Roberts was faced. A requirement that decision simply wasn't one which could be made absent medical evidence. That's the point.
So it goes back to my original question to you. What you're saying is when it's the important issue of impairment being the issue before the court, that absent expert evidence that there is an impairment, the court cannot make a finding of incapacity.
Yes, and I'd only qualify that. But it's not just that the finding of an impairment is serious, it's the consequences.
No, I understand.
Yes.
I'm trying to get to the heart. You see, I'm struggling with this because we had experts. We had the right experts, according to you, and they said that she didn't lack capacity. The judge disagreed, and you say didn't give good enough reasons, but that's a different ground of appeal. This ground of appeal, I'm just trying to pin down, and I think I've got there now, that what you are saying, that because the consequences are potentially so serious, uniquely in relation to expert evidence in this jurisdiction, a judge cannot go behind medical evidence in relation to impairment.
Yes,
That is your submission. This is an exception to the rule that a judge can disagree with medical evidence, with expert evidence.
Yes, if
Thank you.
in a way, but it's not that the judge may often disagree with medical evidence, but it may be in the just as the judge was entitled to disagree if our argument on the order in which the questions need to be approached is incorrect. The judge was entitled to disagree with Dr. Bagchi and prefer Dr. Miners-Wallace's opinion of the...
But was not entitled to disagree with their joint view that she did not lack capacity.
In the absence of any other medical evidence. Now, I'm mindful, and the court's made it clear that the additional arguments that have been raised in supplemental argument can't be relied on. But one of the cases that the trust has put in the bundle, case of Stockport, recent case, deals with those. I just mentioned this, and I'm not developing this argument, but it's dealing with the issue under Article 5 of what those requirements are in terms of establishing the existence of someone in that context is of unsound mind. And the Strasbourg courts made it clear in that context that it does require medical assessment and an identification of a formal disease, of a formal problem, precisely because the consequences are so serious. And that was simply the point that tied into the principle of legality point. Where the consequences are serious, then the judge is required to establish on the basis of an appropriate medical expert that there is an existence of an impairment. And
sorry, just Ty, can I just
yes.
relate this back then to your earlier grounds and your earlier submissions? Because it seems to me to follow from your submissions on these two grounds that therefore it's not only that the judge erred in failing to have either the material or to give proper reasons for disagreeing with the experts, but she was not entitled in any event to go against their view, because this was an impairment decision and a judge, we just clarified,
yes,
is not entitled to go against medical professional view about impairment absent other medical evidence to support his or the judge's view.
Given the seriousness of the consequences, and particularly because Article 2 was engaged in, would have been engaged in a subsequent.
I just want to be clear. So, in fact, we need to tie it in with your earlier grounds as well, because you say it wasn't just no material, no reason. She wasn't entitled to do it anyway. Look at my reasons in support of ground 3.
Yes, I'm
clear now. Thank you.
What I don't want to submit is that, and I hope I haven't, is that requirement exists in all cases, because the Mental Capacity Act has to be flexible.
No, you said in all cases where impairment's the issue.
And the serious consequences which engage, as I put in my skeleton argument, the convention rights, which in this case, especially Article 2 rights engage. A decision is going to be made to withhold, potentially to withhold life-sustaining treatment from someone. And that's a decision which Parliament can't have intended that could be determined absent any medical evidence regarding the existence of impairment. And this is,
strictly speaking, the principle of legality has nothing to do with the Human Rights Act or the Convention rights. The principle of legality existed in the common law before the Human Rights Act was enacted. So one has to be slightly careful to start referring to convention rights. But I think your fundamental submission of substance would be the same, which is the common law recognises the right to life as a fundamental right, and so that's what you actually rely on rather than Article 2.
It is, and that's how I originally framed the grounds. And my learned friend objected to that and said I should have approached this under the Human Rights Act. And so I then said, well, if you want to look at it under the Human Rights Act, one can. And then he objected to my introducing the new dimension.
Well, I understand, for my part, I understand the way you put it. And if Mr. Sachdeva wants to submit to the contrary, then no doubt he can make that point. Indeed, yes.
May I just test your argument in this way? Supposing the psychiatrists concluded that he did not have capacity, but there was substantial evidence from the treating clinicians and the hospital medical staff and the family that she did, would you still say that in those circumstances the court was obliged to accept the view of the psychiatrist?
I was trying to focus the particular issue and the particular competence which the court needed to rely on the medical issue, which is properly one of the impairments, whether that exists or not. Whether or not one, not the issue of capacity, which is, I accept, properly one for the court.
So on the question of impairment?
Yes. On the question of impairment.
Psychiatrist evidence is final one way or the other.
Subject to the safeguards that exist of the party being able to challenge that evidence by calling their own expert if they disagree with it, and all the other safeguards provided by the rules. But it's the medical question, which as opposed to the capacity question, which is then built upon findings of whether there is an impairment. Our question 1, which we'll get to when we look at the order of that the court has to approach these matters. But the impairment issue is a medical issue, and the impairment issue is not one, as opposed to the capacity issue, which the court is, where the matter is so serious, where Parliament could have intended the court to be able to ignore medical evidence. Because whilst the Mental Capacity Act doesn't specify who should be providing who should be providing any medical evidence, or whether any medical evidence is necessary. The provision is framed as a medical term. So disorder, impairment, or impairment of the functioning of the brain or mind.
Someone might have to take us some of the authorities on that, because I'm not convinced that's quite right, Mr. Kundavali. I thought the whole thing was that it wasn't just a medical issue. impairment. You might think about that over the short adjournment, because I think you really will have to make good that argument.
Yes, if I may add to my lady's point, that one also has to be very careful, because some of the terminology, not all of it, also appears in the Mental Health Act.
Yes.
And certainly one would have to be very careful before saying that issues under the Mental Health Act are purely medical issues. Obviously, medical evidence can feed into, often will feed into, the court's assessment. But my lady is quite right, if I may say so. Certainly my experience is more of the Mental Health Act than the Mental Capacity Act. One has to be very careful in this area, just because there are words of the English language which on the page look as if they're medical terms. It doesn't mean that as a matter of law they're medical.
I shall reflect on this.
And just, I know it's awful to have all three of us. But while you're reflecting, can you help me if you categorically say whether your submission that Mr. Justice McDonald's decision in the North Bristol case was wrong? Because he, as I understand it, said that no formal diagnosis is required in order for the court to conclude there was an impairment.
So, in a nutshell, the position is not that my submission is not that he's wrong. The distinction has to be made between, as the ground has been formulated, between a professional diagnosis and a formal diagnosis. What happened in the Bristol case and what happened also in the Pennine case is that there was professional, certainly in the Bristol case, there was professional psychiatric evidence given by Dr. Zachariah, consultant psychiatrist, that there was an impairment. The problem is what the psychiatrist wasn't able to identify is what the precise impairment was. And so that was the issue about whether there needed to be a formal diagnosis or not. And that, as the ground is formulated, it doesn't necessarily go that far. Providing a psychiatrist, in this case, is able to identify that there is an impairment, then that would satisfy that requirement of a professional diagnosis. A psychiatrist could say, look, this person is evidently mad, but I'm not sure precisely what sort of mania they're exhibiting, what sort of problem it is. And as science gets more and more precise, the category becomes more and more precise as well. What I imagine in the past, there weren't all these recognized categories of mental impairments, and they came under broader umbrella terms, and that may be what happened in the Bristol case. A professional is able to say, in that case a consultant psychiatrist, there is certainly or on the balance of probabilities, there's a mental impairment. Quite what it is, though, I haven't yet been able to identify. And so that's the difference between the professional diagnosis, which is what our ground's about, and the formal diagnosis, which is what the Bristol case was about. It's a slightly different issue. Now, it may be that, as the Stockport case shows, surveying the authorities in Article 5 cases, that when it comes to Article 5, you do need to have a formal diagnosis when you're going to deprive someone of their liberty. But this ground doesn't necessarily go that far, and I'm not. That would be the easiest way of reconciling our submissions with the Bristol case. I'll pass on to the next ground and make a start on the next
Certainly,
ground.
that's your functional and diagnostic ground.
This is ground 5 on the order that the court has to approach the question of the three questions that we've identified that need to be answered. The starting point is section 42.5 of the Mental Capacity Act, which is Authorities Bundle, tab 61, page 1169. And that's the requirement of a court to take into account of what the code has to say when it's deciding the question. And the code on page 1186 of the Authorities Bundle, tab 63, stipulates a two-stage test of capacity, whereby the first stage is what I've identified as question number one.
Sorry, where are we now?
It's 1186 of the Authorities Bundle.
If you've got it.
What is the test of capacity? To help determine if a person lacks capacity to make particular decisions, the Act sets out a two-stage test of capacity. Stage one, does the person have an impairment of or a disturbance in the functioning of their mind or brain? Stage one requires proof that the person has an impairment of the mind or brain, some sort of disturbance that affects the way their mind or brain works. If the person does not have such an impairment or disturbance of the mind or brain, they will not lack capacity under the Act. And then at 4.12, various examples are given of the sort of impairments and disturbances which are considered. Stage two is then over the page. Does the impairment or disturbance mean that the person is unable to make a specific decision when they need it? And this stage two comprises question two, functional question, and question three, which is the causal question. And put very briefly, and this isn't a complex submission, what the Supreme Court and JB had to deal with was a situation where the stage one question, question number one, is there an impairment, had already been answered. It wasn't a matter which the Supreme Court had to look at. It was accepted that there was an impairment in that case. And that can be seen from the very first paragraph of the judgment, which is at page 117 of the Authorities Bundle, tab 8. It says this appeal raises issues of profound significance under the Mental Capacity Act. The appellant, and others like him, with an impairment of or a disturbance in the functioning of the mind or brain, which potentially renders them unable to make a decision for themselves in relation to having sexual relations. If we look then at paragraphs 13 to 17, starting at 126. We can see there all the evidence that JB had a disorder of the mind or brain. And this simply wasn't an issue in that case. There wasn't any challenge to whether the impairment existed or not. A review by Dr. Thrift of the extensive GP records reveals that JB has had epilepsy since the age of 2, and that his condition was severe, drug-resistant, and intractable for many years, During some months, he would experience up to 180 tonic-clonic seizures. Due to seizures, he fractures hospitalized. He had as a side effect of one of the many drug treatments, he had developed tunnel vision, registered blind. Then at 14, his epilepsy was thought to have resulted in significant brain damage and cognitive behavioral regression, difficulties with learning and cognitive function, cognitive impairment. And then at 15, he was formally assessed as having autistic spectrum disorder, diagnosis confirmed in subsequent assessments. And then at 17, anxiety and short-term depressive episodes, which may or may not satisfy the mental impairment requirement. But the point is, there wasn't on the basis of the other evidence, there simply wasn't any question in that case that question 1 had been satisfied. So that when the Supreme Court then had to come to see how such a case had to be dealt with, it could skip straight essentially to stage 2 of the Mental Capacity Act stages. And the judgment in my submission in JB has to be understood as a judgment explaining how stage 2 is to be approached by the court. That is the order that the diagnostic and causal questions has to be approached. It doesn't say anything about question 1, because that simply wasn't an issue.
Is the same true of the decision of this court in PC and York? On which I think Lord Stevens relied in part in reaching his conclusion.
I'll have to check on that, my lord. Thank you. But that's certainly, that's my submission. As I say, it's a simple submission.
Mr. Conterville, I'm sorry to ask you a very basic question. Why does this matter? Why does it matter in what order the judge sets out her reasoning, as long as she addresses all the right questions?
The reason it matters is this, because if one doesn't get beyond question 1,
yes,
then the issue of whether or not there's any functional problem doesn't arise, because we stop there at question 1. And therefore, the question as to whether there is an inability to make a decision is not one that the court has to be concerned with. And in the judgment under appeal, it obviously was a matter of central concern. There was this, the whole judgment was focusing on this inability to make a decision relating to the end of life treatment that was being given. And if one doesn't even get to that stage of the reasoning, then that reasoning, which did inform, in my submission, Mrs. Justice Roberts' judgment, wouldn't have legitimately formed any.
You may be right about that. We'll have to consider that submission. But equally, it might be said that if she should never have found that the functional test was met, because she erred in law because she thought that belief was required in order to understand something, then you would succeed. This is your ground 6, and I know you're going to come back to that this afternoon. But if you succeeded on that, then it might be said, well, then she would never have needed to go on to ask, well, what was the cause of that? Because the answer ought to have been that there is no satisfaction of the Mental Capacity Act test. So I'm not, at the moment, I'm afraid, speaking for myself only, I don't understand why the order in which a judge asks the questions discloses an error of law, as long as she does ask all relevant questions and gets the law right.
There's a very practical and important point.
Yes.
That whilst it's true and it's accepted that the Mental Capacity Act needs to be flexible and broad in its approach to cope with all sorts of different situations and all sorts of people who need the help of the law, it's also the case that it's important that people who don't come under the Mental Capacity Act, because there is no impairment, are not are not faced with having to spend the last 7 months of their life fighting proceedings, which wouldn't have been necessary if the first question had been asked. And that's why this ground is important, I submit.
Is that a good time to adjourn?
It is.
Could I just raise a couple of points thinking about? First of all, I believe that the General Medical Council has somewhere issued guidance saying that the assessment of capacity is a matter of general medical training and not a matter of specialist evidence. Now, could you just think about that over the short adjournment?
If it assists, my lord, I was going to provide a copy of that because in an observation you made triggered that thought, so I've already got copies already lined up to be printed for you.
I mean, probably what's in the Court of Protection Practice about that. The second question is this: you've been citing at length from the Code of Practice. Now, of course, the Code of Practice is now some nearly 20 years old and is in the process of revision. For my part, I'd be helped by just having a clear understanding of where that's got to and what impact the fact that it's under revision has on our decision. I'm not asking you to make any comments now. For example, there are lots of other areas where it is accepted that the Code of Practice is no longer applicable because it's been what's said in the code has been overtaken by other matters, including authorities of this court. Thank you.
2 o'clock. Thank you very much.